A Kansas substitute teacher has been arrested and is now facing several serious charges, including unlawful sexual contact with a student and giving alcohol to minors. According to authorities, the alleged crimes took place earlier this year and reportedly involved high school students between the ages of 16 and 17. Investigators say the teacher engaged in inappropriate behavior while in a position of trust and authority, raising major concerns about student safety and school oversight. I'm your host, Kennedi Walker, and you're watching Law&Crime. For this story, we turn to Wichita, Kansas, about 2 hours from Topeka. That's where a substitute teacher is facing serious charges, not only for illegal behavior, but for conduct many consider deeply inappropriate given her role in the classroom. Her name is Whitney Shull. According to her social media accounts, she's married with children. Court documents say Shull had allegedly had sexual contact with multiple minors, specifically students who were just 16 and 17 years old. The district attorney's office says the alleged crimes happened between January 31st and March 15th of this year. The criminal complaint identifies several juveniles by their initials only. In one case, Shull is accused of fondling a minor in January. A student police say was enrolled at the same school where Shull was working as a substitute. The complaint also alleges that Shull held down another student by their wrist and attempted to force the victim to touch her. And in a third case, she's accused of touching a minor while they were unconscious with the intent to arouse them. Prosecutors say Shull also hosted gatherings where minors were present and consuming alcohol on more than one occasion. This investigation began after the Sedgwick County Sheriff's Office confirmed it was looking into reports involving students and staff within the Nickerson South Hutchinson School District. As a result, Shull is now facing multiple charges, including unlawful sexual relations, attempted unlawful sexual relations, aggravated sexual battery, and 2 counts of hosting minors consuming alcohol. The 39-year-old has bonded out of jail, but a protective order has been issued blocking her from contacting the alleged victims or any witnesses in the case. According to the school district, Shull is no longer employed there. And joining me to talk more about this is criminal defense attorney and former prosecutor Jess Hamey. Jess, thank you so much for coming on today.
Happy to be here. Thank you.
So let's start here. We've got a substitute teacher accused of serious crimes involving minors. Does the fact that she was a substitute and not a full-time teacher change anything legally when it comes to charges involving students?
No, not at all. Really, the statute in Kansas says that anyone in a position of authority, a teacher position, a mentor position, or otherwise can be included in that statute.
And we're looking at several victims here, all underage. How does that number affect the severity of the case from a prosecution standpoint?
Well, it certainly lends credibility to the stories of each of the victims when it comes time to testify. Their stories are likely to be consistent in terms of motive or operandi. So it just really lends credibility to what each of them is going to say, to have other people saying similar things at least.
And what about their ages? Does the fact that the students were 16 and 17, not younger, impact how this is charged or prosecuted?
It certainly does. It reduces the severity of the offenses. The fact that they're 16 and or 17, each of the victims respectively, makes the charges a little less severe. If they would have been 14, 13, obviously the charges would have been significantly different.
Look, I know I say this all the time, but truly covering these stories day in and day out, you realize things are a bit crazy out there. That's why I am so excited to tell you about a product we at Law&Crime created, the Law&Crime Safety Bracelet. This is a bracelet you can wear around your wrist or keep in your car or in your purse, and it includes multiple items that give you actual peace of mind. I'll show you what I mean. A whistle, which has a classic high pitch, great for drawing attention when it matters most. A compact flashlight that can be used to guide you in the dark or signal for assistance. A seatbelt cutter you can use in case of a car emergency, and a handy utility knife for multiple uses. And these are just to name a few. So right now you can go to truecrimegoods.com and use promo code SAFETY15 for 15% off. That's promo code SAFETY15 for 15% off. Order your safety bracelet now and carry confidence everywhere you go. She's facing charges like unlawful sexual relations and aggravated sexual battery. Given the nature of those, how many years could she realistically be facing if convicted on all counts?
Well, in fact, there's two counts of unlawful sexual relations, and the second of those counts is just an attempt. So the first count against one of the victims is unlawful sexual relations, which, per the complaint, implies that she actually touched or fondled the genitalia of the purported victim. The second one is an attempt, which in Kansas reduces the severity level by 2 counts. So from a level 5 down to a level 7. In Kansas, we have a sentencing guideline grid, which determines the disposition of the charge by severity and criminal history. So the fact that they were 16 and or 17 reduces the severity, but also the attempt on the second victim reduces the severity of the offense just a little bit more.
How many years are we thinking if she is convicted?
So the top count, what we call the top count, is the most severe of the charges filed. That is a level 5. And in Kansas, depending on criminal history, so if she doesn't have any criminal history whatsoever, the low number in that box is 31 months, all the way up to if she has 3 prior person felonies, which is highly unlikely given that she was a teacher. She wouldn't be teaching if she had felony convictions. But nonetheless, the range is anywhere from 31 to 136 months in prison if convicted of that top count.
And is there a chance that that could get pled down?
Well, there's always a chance. Plea bargaining, as you know, is part of the process. The second count is a level 7. And the reason I mention that is because the level 5 is a presumptive prison box. So if she is convicted of that top count, which is the actual fondling of one of the victims, then she would be presumptively going to prison. The second count is a level 7, and that puts her in the presumptive probation range. So even if she's convicted of that second count, she would be looking at probation probably up to about 24 months. In Kansas, the maximum probationary period is 5 years, but the standard for a level 7 is only 24 months.
Yeah, I was just about to ask, when plea deals happen, do they look at, whether maybe she had a family? I know, of course, they look to see if she has any other crimes in her past, but, I'm just trying to figure out, how do they determine, okay, no, she's going to get a much lesser sentence. Maybe it's because she has kids at home. Maybe it's because, just other factors.
Yeah, absolutely. Now, I neglected to mention that top count even is what we call a border box. So the presumption is prison, but that's a rebuttable presumption by a showing of certain factors, specifically that she's subject to a treatment programming, that there's a treatment program available for her for whatever she might need, and to be rehabilitated serves the community's interest more so than just going off to prison. So even if she's convicted of that top count, there's a fair chance that probation is the likely disposition. Now, having said that, there's a special prosecutor in this case. The Reno County, Kansas District Attorney has excused himself, had a conflict of interest in the case. So he appointed or requested the assistance of a special prosecutor. And that special prosecutor is the district attorney here in Sedgwick County, the neighbor. And generally their practice here in Sedgwick County is to charge the most severe crime that they can possibly get. And that enables attorneys then to have some room to work in terms of plea bargaining. So I think the likelihood of the defendant in this particular case going to prison, either because of conviction for the top count being reduced, or because she pleads to maybe the second count, that second felony, probation is the likely disposition for her.
Well, let's just take a deep dive into the charges here. There's a disturbing detail. One student was allegedly unconscious when the touching happened. Right. Does that elevate the charge or potential sentence?
Well, that's the attempt count. That's that second count for the attempted unlawful sexual relations with the teacher. And in that particular case, it says the complaint suggests that she held him down by his wrist and attempted to have him touch her. So the fact that he was unconscious would be important if this was a rape, if there was some actual fruition of the crime. But in this particular instance, the way it's charged suggests that despite the fact that he may be unconscious or passed out drunk or whatever the case may be, and nonetheless, the crime was not completed. It's an inchoate offense of attempt.
Right. And then even with you mentioning, she allegedly held down a student's wrist, could that even be considered a form of force, even if there wasn't penetration involved?
It certainly could be, but it hasn't been charged that way.
Okay. Is there any way they could do we see they usually upgrading charges or maybe not in a situation like this?
It is always possible. See, in Kansas, when a complaint is filed on felonies, you have a right to a preliminary hearing. And that preliminary hearing is basically for defense attorneys. It's an exploratory opportunity to see the evidence, hear the witnesses, have an opportunity to cross-examine them to get a better idea how the case is going. And there are a lot of prosecutors, unfortunately, in Kansas, that when you go to exercise that right to a preliminary hearing, they punish you by adding charges. They enhance the charges if the evidence supports it. So they do what they can in Kansas, the prosecutors, to avoid the necessity of victims, particularly young victims, having to go through the trauma of testimony.
Speaking of that, just the trauma of testimony, if because there is a lot of cases, that I see about where a lot of victims, they decide, hey, they don't want to do this, or again, the trauma, their parents don't want them to testify. Maybe they're afraid of their identity becoming public. What usually happens when a victim backs out of testifying? Does that help the defendant?
Well, before the charges are ever levied, the cops, the investigators, have generally locked in the statements by the victims. And those contemporaneous statements made closer in time to the date of event are generally reliable, more reliable. So when a witness recants or decides they don't want to participate anymore, they're usually locked in. Having said that, the prosecutors have some discretion on whether or not they're going to, how much weight they're going to give to the victims in terms of their ability to affect the outcome of the case. Some prosecutors appreciate, hey, I know this is a traumatic event, but it's really important to get a conviction to protect the rest of the community. And then there are some prosecutors like me. I used to be a prosecutor, and I did what I needed to do despite the victim's participation after the count was charged. So and that's really common in domestic violence incidences, where a couple months later there's reconciliation, or they have a change of heart and they don't want to testify. As a prosecutor, you have discretion to say, no, I know what happened and I'm going to continue the prosecution. So this prosecutor, the special prosecutor, is one of them that he's very mindful of the trauma of testimony for victims, and he gives them a great deal of credit and fairness, some say in the disposition, so to speak. But he's going to get a conviction one way or another, and probably it'll be a felony, because in Kansas, if you have a felony conviction, you are done teaching. And that will be ultimately an objective, I imagine, for the special prosecutors to get a felony conviction so she is done teaching.
If she does get a felony, does this go on her record? Meaning, like, will she potentially have to register as a sex offender?
Yeah, that's a really good question. Unlawful sexual relations is one of the numerous sex offenses in Kansas that requires registration. The period of registration is dependent upon the severity of the offense, again, the number, and also the type of offense. Now, unlawful sexual relations is one of those offenses that could require up to 25 years of registration on the Kansas Offender Registry.
Moving on to some of the other things that this substitute teacher is charged with. We know that she allegedly gave alcohol to minors. How could that
Right.
play into the bigger picture legally? Could prosecutors use that to show a pattern of grooming?
Well, I think that's why that second incident, the incident from March, is important, to show that this was not just an isolated situation where some kids showed up and got into the refrigerator. This is a pattern. This is not the first time that this has happened, and providing alcohol could very well be part of the impetus for the offense, the sex offense, really. Get them liquored up and have a freak off, I guess.
Freak off, like Sean Combs and
Yeah,
Cassie Ventura.
yeah, something
Yes,
like
I
that.
recognize. Right. Well, is it likely the alcohol charges would be handled separately, or do you expect all charges would be tried together?
No, they're all going to be tried together. It would be really difficult to try to separate these offenses, and they're charged in the same complaint, both dates, the January date and the March date. So having them in the same complaint makes it really hard for defense attorneys to try to separate them at this point. But even if they were separated, they could be used as prior bad acts. So, if the March incident there's a conviction for contributing alcohol to a minor, and then that's part of the allegation for the January sex offenses, then you could use that as a prior bad act. So you're danged if you do and danged if you don't in terms of the alcohol charges.
From a defense perspective, what kind of arguments do you think her legal team might try to make here?
Well, it's hard to tell. I think what effective defense attorneys try to do now is bring into the picture kind of the human element. What's the rest of the story? What was going on in her mind at that time? Aside from the facts, if you get into a preliminary hearing and the witnesses are unreliable, then you've got issues of fact that you have to address. But there's only really two types of criminal defense cases. One is where the facts are an issue. Did this happen? Did a crime occur? And the second one is mitigating the damage. If the facts or it looks like the evidence is so strong that they're going to be convicted of something, then you transition to keeping them out of prison. Or reducing the severity of the offenses such that there's not a significant collateral effect for the rest of their life.
Well, if you could explain just how hard is it for the prosecution to prove things like intent to arouse, especially if one victim was unconscious?
It's not difficult. In Kansas, that intent to arouse, satisfy the sexual desires of the offender or the victim or both is pretty simple. It's particularly when you're talking about sex organs, fondling of the sex organs. There's really no good, well, at least in my 25 years, I've never figured out a good reason to do that other than for sexual gratification.
Right. Well, the school, do they play any role? What role do school officials usually play in an investigation like this? And could they potentially be held liable?
Well, there's two questions there. First of all, is what, in terms of liability, what, if anything, did the school do to protect the children by virtue of backgrounds, doing some research? Do they have a teacher certification? As I understand it, this is a substitute teacher. So there is some relaxed certification requirements for substitute teachers. So I imagine there are some people in the community that are pretty concerned about, what is my school doing to make sure that the people they're putting in place as teacher are safe. The other part of your question is not really, is it a part of the elements of the offense? Obviously, unlawful sexual relations, this is charged that because of her position as a teacher, it's a crime. Otherwise, it may not be a crime. So because of her position as a teacher, you really just have to show, one, she was a part of the faculty at the school, and two, she perhaps met these kids or had some role in their education, or maybe she was a teacher for them, or had some other role in the school. You just have to show that she was in some position of authority with them. That's easy for prosecutors.
Do we ever see instances where maybe the victim's parents sued the school district because of an incident like this?
It happens. I haven't experienced it in all my years of working teacher cases. I haven't experienced that the schools have been successfully sued. Obviously, the buck has to stop somewhere. So I've seen principals go down and have to switch jobs or take other positions, or vice principals who do the hiring and firing of teachers who didn't do a sufficient job in background checks. But a gross deviation from the standard of care sufficient to have a tort claim is pretty rare.
Now, the suspect has bonded out of jail, but there's a protective order in place.
Correct.
Can you explain why judges usually put this in place, and what happens if she violates it?
So the protective order that you're referring to is she can't have any contact with victims or witnesses identified in the complaint. And the purpose for that is basically to avoid defendants, trying to dissuade the victim from testifying or trying to beg them to change their testimony a little bit in a favorable way, basically witness tampering. And two, you just don't want to have the defendant and the victims around each other. And so courts always order that. A violation of that order will result in the immediate revocation of the bond, and the likelihood that the bail would go way up. the likelihood of getting out again pre-trial would be pretty slim if she violated.
Now, we get a lot of questions and, asking about female teachers or female defendants in many cases, not even teachers. But in cases like this, in your experience, are female defendants treated differently than male defendants would? Maybe a female substitute teacher versus a male substitute teacher. Could you explain that?
Well, are you referring to the courts or the public? The
The
courts
courts,
are.
or both, honestly.
Honestly, the public is significantly different. I think we've seen that time and time again, that attractive female teachers, there's a different kind of outrage for them than there is a male teacher. But the courts know the elements are the same. Was this a teacher? Was this a touching done with the intent to arouse? The elements of the crime are the same for teachers, whether they're male or female. I think that it's really difficult, though, with male teachers to, she is innocent until proven guilty beyond a reasonable doubt, right? And that is a really hard, in practice, thing to address with male teachers in particular, because there's so much outrage for teachers, male and female, but in particular for male teachers.
And before I let you go, what does a potential timeline look like here? Could she be going through the court process in a couple of months, in a year from now? Can you break that down?
Sure, she has a right to a speedy trial. So she has a right to have a trial within 6 months. But that rarely happens. In part, too, it's part of the defense strategy. Time is a healer. And so drawing these cases out over months or maybe a year is generally helpful for everyone involved. Prosecutors have time to put their cases together. Defense attorneys have time to put their cases together. Victims have time to get rehabilitation. Defendants have time to get evaluations and rehabilitation and address the issues that cause them perhaps to commit the crime that they are alleged to have committed.
Well, this is a case that we will be following closely. Jess, thank you so much for coming on today.
Of course. Happy to be here. Thank you for the time.
Whitney Shull's first court appearance will be June 9th. For Law and Crime, I'm Kennedi Walker.